These are the plaintiffs, Scotty Larkin and Cherry Duncan. They say they rented a house from the defendant, and when they left, they were told they could leave their Cadillac in the driveway for a few days while they moved. When they returned to retrieve the car, it was gone. The defendant had it towed away. When they asked him why he didn't contact them first, he told them he couldn't find them. That's odd, considering they were renting a different property the guy owned. They're suing for $5,068, the car's value. This is the defendant, Chris Gordon. He says the car had no plates. He called, he mailed, and he posted a notice of abandonment on the plaintiff's door, and they ignored him. He had no other choice but to tow the broken-down car to a storage facility. The car is theirs to pick up, and he certainly owes nothing because he did everything by the book. He's accused of acting catty.
Scotty Larkin and Sherry Duncan, you are suing Chris Gordon and Gordon Properties, LLC, represented here by Chris Gordon, for $5,068 that you say you are out as a result of him negligently tossing a Cadillac that you had, towing a Cadillac that you had, thinking it was abandoned when it wasn't. Tell me what's going on.
We were renting a house from him, and we moved to an apartment that he also owned.
Okay, you own both those properties, or you just manage them?
I manage them, Your Honor.
Do you own them?
No.
Okay, so go ahead.
And he gave us a letter. We had left the Cadillac there because it wouldn't start. And so we got a letter to...
But what gives you the right, though, to leave the Cadillac behind just because it wouldn't start? That's your problem, right? Don't you have to tow it somewhere and that it has a right to be?
Yes, it was.
Okay.
It was just going to be a couple days until we got the tow.
Did you tell him that and get his permission to do that?
We have a letter from him that gives us...
That's not my question. First, answer my question. Did you call him and ask permission to leave the
No,
Cadillac?
actually, someone from his office, I believe her name was Jennifer, I'm not sure, came to my door to have me sign a release of property.
And that's after several days that your lease was over on when? March 30, the end of March, right?
Yes.
And it's April 6th, and they come to you to say, what the heck, because all this stuff was left behind.
Oh, no, we've
right?
been in contact.
That's my question. I've asked you
Yes.
that 3 times, and you keep tossing me to other places. Did you call them and ask permission to leave the Cadillac?
Yes.
Who'd you talk to?
I talked to Jennifer.
Is Jennifer here?
No, Your
Nope.
Honor.
Okay, who's Jennifer?
She's our secretary.
To your knowledge, did they speak to Jennifer before leaving all that stuff?
No.
Okay, so go ahead. Do you have an affidavit from Jennifer?
No.
Okay. This is in your complaint, you don't say that, by the way. All right, now, several days pass, and you are contacted for sure by them who say, what gives? What's going on? Which is odd if Jennifer knew what was going on. What do they tell you?
That I have until the 14th to get my property from
Okay,
that.
and does she tell you that verbally, or does she put that in writing?
She told me that verbally,
Okay.
and I have it in writing.
Okay, now, you have it in writing because you got something in the mail, or they posted something, or both?
She came to my door. She didn't give me it then. She just had me sign a release,
Okay.
which I wrote
Now,
on the bottom of it.
release is not about the Cadillac, I guess. Well, I mean, the release, from their perspective, was about everything, but you sign a release, but you specifically write, we'll be by to pick up the Cadillac.
Yes.
Do you have a copy of the release that you gave them?
No, I don't have a
Okay,
copy of
you
it.
guys have a copy of it, right? Can I
Yes,
see
ma'am.
it? I realize sometimes it's not feasible because people don't walk around with a copy machine in their pocket, but if you ever sign something, do you have a phone that takes photographs?
Yeah.
You should always take a picture of what you sign. Just word to the wise for the future. They have it. So. Abandoned property release. This notice serves as my release for all property left at the rental. I am releasing any claim to this property because what? How much stuff was there?
A lot, Your Honor.
Like what?
Broken television, mattress, clothes, food, debris in the yard, around the car, in the garage. I have lots of pictures, if you'd
Can I
like to
see
see
the
it.
pictures?
Absolutely.
Why are there 2? There's one that she just signs, and there's another one that she signs that says, we will pick up the car in the driveway. So why are there 2?
Well, I believe, Your Honor, one was meant for them to keep as a copy.
And then they didn't take
they
it?
gave them back, both back. And actually, we also have another release form signed the following day from Cherie,
Okay.
indicating again that the belongings can be released. It's the bottom of that form.
Can I answer why there's 2?
Yeah, if you know.
I had filled one out and gave it to the on-site maintenance manager before Jennifer had come to my house to have me sign another one. And
Right.
I told her that I gave it to him, and he said he hadn't. She said that the maintenance man hadn't dropped it off to
Out of
him yet.
curiosity, why didn't you write the note on the other one? We will pick up the car in the driveway.
Because he had already sent us the letter saying that we had until a certain date to come get the car.
This notice serves as my release for all property. I am releasing any claim to this property. I am giving my permission for the property to be disposed of. Weren't you worried that signing something like that might be a problem in terms of claiming later that, no, I want $5,000?
No, I wasn't, because I
Was
told
the
her
car,
verbally.
was the Cadillac running or no?
No,
It did, right, you told me that you would have had to tow it. And what year was the Cadillac?
92.
Okay. And how long had it not been running?
Oh, it just went out just a couple weeks prior.
Where did you get that you had until the 14th?
This notice here from them
Okay. And you received that notice how?
in the mail.
Okay. Now, who authored this? You did?
Yes, Your Honor.
Okay. And you see that it says the 14th, right?
Correct.
All right. Now, there's other notices that you gave her that don't say the 14th, that say the 13th, right? Why'd you get rid of it on the 13th? You got rid of it on the 13th, right?
Yes, Your Honor.
Okay. You had it towed by the towing company to their locale
Correct.
on the 13th. Why, if you had given them until the 14th, did you do that?
Because they signed the waiver allowing us to disregard the 14th date, Your Honor, and dispose of their belongings.
But don't you see, just like I asked them, don't you think that's confusing? Don't you think that's confusing? Because clearly they were confused. Because they show up on the 13th, right?
We came
Ready
with
to
the tow
tow the
truck.
car because you couldn't just show up and take it.
Yes.
Yeah,
So you had the tow company there?
No,
My mother's husband came to tow the car. He has a tow truck.
Came to tow the car.
Yes, he did.
All right, and then you go there and lo and behold, the thing's not there. So they clearly were confused. And do you see how the conflicting, did you just forget that you'd given them until the 14th?
Oh, no, Your Honor, no, I do this all the time.
Okay, so you knew that there was a notice out there that said you have until the 14th?
And I also knew that they had signed off on the 11th and the 12th, giving us permission to remove
Okay,
their
but in
belongings.
this one that they sign off and they say, we'll pick up the car. It's clear they want to pick up the car. So if they want to pick up the car from this one and you give them till the 14th to pick up, why don't you just play it safe and wait until the 14th? Why do you have to have such an itchy finger and call the tow company on the 13th
Well, Your Honor-
and create an issue? Right? It doesn't seem like such a good idea now, right?
So, if you leave a car behind, even if it's broken down, do you have a reasonable expectation that the landlord's going to keep it there when you move?
I mean, if you move somewhere and someone else lives in your house, it's his property now.
So you just think it's abandoned once you move?
I mean,
Is it abandoned once you move?
I believe so, unless you prearranged it, which I don't believe.
It's not prearranged.
Yeah, so you left it, you abandoned it. It's
Tough luck.
gone. Yeah.
It's called tough luck under the law. Going inside the courtroom.
Well, I can understand the confusion, correct, Your Honor,
Right.
correct.
And we're here because of that. Like if you just waited till the 15th, everything would be hunky-dory.
Right.
Right?
Yes, Your
Let me
Honor.
ask you a question. This is, you're asking for $2,800. The Blue Book value of a car that's not running, that's that age, is not $2,800. And you also want every penny you ever put in fixing the car throughout the years. Okay. At the time that you realize that it's been towed, because they tell you, hey, it got towed, right? And you call the tow company, how much would it have cost to get this $5,000 problem out of the tow shop?
$370, I believe it
Can you
was.
prove that?
just moving, I didn't
Okay,
have.
the towing was $155, and then the dispatching was $15. So that's a total of $170. Any other charges that I'm seeing here are charges that accrued because you let it go and didn't pick up the car.
I couldn't pick up the car.
Why not?
I
It would have
just
taken
had-
$170 to solve this problem. Then you could sue him for $170. But you're suing him for $5,000 because you let a $170 pimple turn into a $5,000 abscess.
If I had
By the
the-
way, the car ended up where?
It was sold at auction, Your Honor, for $605. I
To
have the
pay
paperwork.
off the bill.
Although the total tow bill is.
Are you still living in the place?
He sold the place.
The
So it's
apartment.
under new management.
Okay.
So can I answer the
Yeah.
question?
Yeah.
I would have gotten the car out if I had the money. I didn't have the money to get the car out.
Why would you sign on April 11th something that says, get rid of all my property without saying anything about the car, which is well after, it's 5 days after the day they tell you you have until the 14th? This is like a new contract that you have with them. I just don't understand.
Because Jennifer had come to my house
I
and she
understand why you said, but why wouldn't you write there, don't take the car, I'll pick up the car tomorrow on the 12th.
Because I had just
Why
the
didn't you
day
do that?
before.
No, you
And I
didn't.
had
You did, no,
told-
no, no. It was
or-
5 days before that they sent you a notice saying the 14th.
No, the one I
Then
wrote
the
on
date,
the bottom.
they both have the actual exact same date. On one of them, you write, we will pick up car in driveway. You don't even say when. On the other one, you don't write anything. You know what? I'm willing to give you the benefit of the doubt that they caused the confusion by putting the other date. But I will not give you the benefit of the doubt when you sit back and say, cha-ching, let that cash register ring. For 170 bucks, I can get my hunk of junk out, but I got nowhere to put it. And it don't drive. So I'm going to take the deep pocket. And that's what you can't. You can't do that. You have a duty to mitigate your damages. For 170 bucks, you could have gotten that car out. I'm ordering you to pay them 170 bucks. That's my verdict.
Just hold on right there, please.
The plaintiff sued for $5,000 and some odd and came out with $170. What's your reaction?
The judge needs to slow down and listen. She asks questions.
How
but
come
she
it's always the
doesn't-
judge's fault when people lose?
Well, you're doing the same thing. You ask a question, but you don't give somebody a time to answer.
Go ahead, give us a great answer that's going to change everyone's mind.
It's not going to change any minds.
That's it? That's what we waited for?
What could we do now?
Well,
You're not the judge.
You have a
can't change
legal
anything.
obligation to
If
mitigate
I had
your damages.
$170, I
And
would
whose
have
fault
gotten
is
my
that?
car.
The judge's fault. Okay. Here you are. Head right down that way. Come on in here. You satisfied how this thing comes out?
It's fine.
You jumped the gun a little too. Well, what's with all these different dates and signing different? You should have waited too.
Well, landlord-tenant law is very complicated.
Harvey?
Short and sweet, you can't just sit on your hands and let damages build and build and build. You have a legal duty to minimize them. And that will do it for this case. Litigants for the next case on the way into the courtroom right now.